Hello, this is Sachin Sawant, your UK immigration lawyer. Today I am going to talk about excess absences. So, excess absences for British citizenship application, that is naturalization for adults. Naturalization as a British citizen under the 5 year qualifying period. So, there are two qualifying periods, one is a 5 year period and a 3 year period. 3 year period applies only to people who are married to British citizens or are civil partners of British citizens. Everyone else falls under this category, so which is a 5 year qualifying period, 5 year residence period. We do get asked questions about this many times, hence I wanted to touch on this one first. Usually on the home office website you'll see that 450 is the normally allowed absences, but we've seen from experience and even in the guidance and all, you'll see total number of absences 480 are normally disregarded without asking any questions. So this 450 doesn't make much sense, but 480 is something that needs to be considered. Up to 480, no questions will be asked. So when you give your absences, you have to report on the form your days in and out of the UK. The form automatically calculates it. And if it is within 480 or up to 480, it's perfectly fine, no explanation, nothing else required. However, there are individuals who have more absences. So the rule for the excess absences in the 5 year period is that up to maximum 900 absences. Instead of 480, it will straight jump up to 900 are allowed, provided these are the criteria to be met. One, all other requirements are met. What does that mean? You pass the life in the UK test, you miss the English language requirement, you are of good character, all of the requirements that you see on the form. You have 2 referees, you don't have any other issues. So basically everything else you are meeting on the form, only this one is an issue that you are considering, that your absences are more than 480. So if your absences are from between 481 to 730, one of the important things is you should have been in the UK, resident in the UK for 7 years. So usually you get indefinite leave to remain in 5 years. And if you are in the 5 year route to this 5 year qualifying period, definitely you will have to wait for 1 more year. So after 6 years of minimum residence in the UK, you would apply for it. But if your absences are 481 or higher, so if you are 481 up to 730, so less than or equal to 730, between 481 and 730, you will have to wait, may not be not just 1 year, maybe 2 years after your ILR if you only completed 6 years and you're trying to apply. Okay, so yeah, if it is confusing, so you get ILR after 5 years. In most of the categories you do get generally tier 2 skilled worker, spouse visas. Most of the categories 5 year is there, some are exceptions, small areas. So then you wait for 1 more year and then you can apply for naturalization. This is the normal trajectory of applications that you will see. However, if your absences are more than 481 in the last 5 years before the date of application, that is from the 6th year backwards, counting 5 years, then you should have been resident for 7 years. So you may have to live in the UK for 1 more year and then apply. And at the same time, these should be met. So between 481 and 730, 7 years residence, number one, all the requirements met. And the third one is you have in the UK, you have established 3 things. One is an established home. You may be renting it, but that's fine. But if you own your own home, that may add value, but it's not necessary. It doesn't mean that you have to own your property. You may be having your own reasons for renting it, but you have an established home. So that's your main home basically. There is no specific definition. You may have to speak to us and we can understand the situation and circumstances, and then we can advise if you do qualify under this. But if you do own your home, more or less you may meet the requirements. So secondly, family. So if you have a partner, husband, wife, or partner, children, so if you have your family, that will help the case. So you have established home, established family, and estate. So estate, not all of your estate, but substantial part of your estate. So substantial is an arguable point. Substantial can be 51% you hold in the UK of your whole estate, 49% you may be holding outside, but not necessary. There is no such specific formula. Mainly, yeah, they are expecting that most of your estate is in the UK. Yeah, you may have to, if this is the case that you want to discuss, definitely book a consultation with us. We may have to take specific facts, your timelines, time spent, what estates you have outside, what estate you have in the UK, family, etc., even established home. So on these three criteria, it's a very discretionary area, so it will not be very straightforward. Definitely I would advise book a consultation with us, discuss with us, and then take it forward. We have experience dealing with this. I've done many successful applications in this area, and yeah, so that is one side. Secondly, so this is all about the 481 to 730. If your absences are from 731 upwards, and so between 731 and 900, so you should have been in the UK for at least 8 years. So remember that you should have been living in the UK for a period of 8 years. So then you may not have to wait for 7 years, but you will have to wait for further 1 year, and only then you can apply. No doubt all these criteria have to be met. Okay, the same criteria, explaining again, you should meet all the requirements. This is important here, you should be meeting all of the requirements, because you are asking for a discount on this requirement. You cannot ask for a discount on any other requirement. That is the logic behind that. So and you have in the UK, you have established home, you have established home, family, and estate, substantial part of your estate. So estate means your investments, your properties, anything, either physical assets, you have stock, shares in any form, whatever monies, anything that can be converted into money or money's worth. Okay, so that is all about the absences in the 5-year qualifying period, normally excluded. So just to summarize, 480 standard, they will be allowed, no problem. But if it is between 481 and 730, then you should have been resident for 7 years and meet these requirements, all the requirements, plus home, family, estate, most part of your estate. And if your absences are between 731 and 900, then you should have been resident for 8 years and meet all the same requirements. Also, there is a note with the 8 years one. I'll just read that out to you. So unless the absences were as a result of, okay, so if you don't want to wait that 8th year, you would only get the option of applying maybe in the after 6 years also. So for absences exceeding 730, you should be, I'm reading this out from the rules. For absences exceeding 730 days, you should be a resident in the UK for the last 8 years, unless, so if you don't want to be waiting, then you have to meet this criteria, unless the absences were as a result of one of the following. And they have given a note: if you are working for the UK government, Crown Service, etc., and you are posted abroad, that is an exception. Secondly, unavoidable consequence of the nature of work. For example, you are, this is just an example that is given, but there may be many similar cases in this new world, remote working, technology, etc. So this is a very crude example. In the olden days, it has been if you are a merchant or seaman or someone working for a UK based business which requires frequent travel abroad. So yes, that may be an exception. Yeah, I've dealt with such matters also where there were absences higher than this and not using this criteria, but the main exception was they were working for employers and employer required them to travel. In such cases, definitely take our advice. It's a tricky one. Sometimes the application may be refused if proper documentation and explanation is not given. We have done several successful applications where individuals were required, even employed and self-employed individuals, or also they had meetings, etc. They gave all the evidence and we were able to make representations and get the application successfully. So if your absences are excess, any of this criteria, even if you want to consider yourself under any exception and not want to wait up to the 8-year periods and you want to apply within the 6th year, so after completing your 5 years of qualifying, you would need some evidence from your employer or self-employment or something similar. It's not necessary you have to fall within those criteria, they are just examples. So, and another example is exceptional or compelling reasons of an occupational or compassionate nature, such as having a firm job offer with British citizenship is a genuine requirement. It's a hard requirement to meet, but yeah, if that is what you fall under, you need British citizenship for that job to be given to you. Yeah. So those are the only ones, and they also say very rarely absences over 900 would be would be excused. So yeah, so 900 is where is the stop, whistle stop. And yeah, so that is all about it. 5-year qualifying period, 480, between 481 and 730, 7 years, 731 and 900, 8 years. If you are meeting one of those exceptions, then you don't have to wait 8 years. Even if you are up to 900, you need to have that exception of maybe for your employment, etc. And there is also another rule about the last 90 days. So I'm adding that here. So this is 480 is in the last 5 years. This is one side of it. This is 1 plus 2. So this is the requirement in the last 12 months. So last 12 months. Last 12 months before the date of application. That's when you submit the application and make the fees of the government, make the government fees payment. So normal permitted 90 days. So the same way, this 450 over here it is 90, and then instead of 480 over here they allow 100 days. So ignore this 90, 100 is normally disregarded in the last 12 months, 480 is normally disregarded. I will give a comparative analysis. Last 12 months 100 is normally disregarded, 480 in the last 5 years is normally disregarded. And so if your absences are, so the same lines, let me draw total number of absences. Now is if only, okay, so the rules exactly remain the same, but the days change here, 101 to 179. So then you have to meet all these requirements. So I would name it as A, 7 years residence, 8 years residence, and B with B1 and B2. B1 is all of the requirements you meet, and B2 you have established 3 things: home, family, estate, substantial part. And over here also, so 101 to 179 absences, you meet all of the requirements, and so basically you are meeting B1 and B2. This is what you're meeting. Then up to 179 it would be disregarded. So you can go with a combination of 481 and 730, P and Q. So 481 to 730 in the last 5 years, 7 years residence, and in the last 12 months if you have total of 179, that would be fine if you have this. And they don't have to go together. You may not be meeting. I have dealt with clients where people are not meeting this and they satisfy it with the B criteria, B1 and 2. Sometimes people don't meet this one, but they are meeting the other side. So not necessary. You can either not be meeting, you may not be meeting both the sides or just one side. So that's perfectly fine. Then 101 to 179, and the second one is between 100. Yeah, here the numbers become a little bit 179. So they have 2 definitions. You meet all the requirements, and total absences may be disregarded if you do not meet all of the requirements. So only the do not meet option is over here. So this is how I would put it. So you have 101 and you have B1 meet all the requirements, and B2 home, family, estate. So B1 and B2. So either you have 101 plus B1 plus B2, or you don't have B1, you don't meet all of the requirements, whatever may be the requirements, but you do meet B2 and the absence justified by the Crown Service or occupational companion as account. Okay, so those exceptions of note 1, your employer has asked you to go, you have a letter from employer, self-employment and all of that. So even if you don't meet all the requirements, you have to at least meet this. So this is the crux. You have to have met B2, which is you have in the UK established home, family, estate, substantial part of your estate. And then even if you don't meet all of the requirements, on the last 12 months option, you have the explanation where if your employer needs you to go, your self-employment needs you to go, your business travel is required, compassionate reasons, someone is sick outside, you are taking care of that person, you are sick outside the UK, I have dealt with all types of variables in this. We have explained, we've got doctor's letters, hospital letters, death certificates, birth certificates, anything and everything, pregnancy complications. So I've done almost all types of matters, so successfully, yes. So anything on this, if you have any question, we've always got a positive response. I'm not guaranteeing 100% results, we don't do that, yeah. So we will try our best, but every time I've done it, I've got it. I've always seen that. So yes, it is something that you should try. I know many times people shy away and they try not to apply. I've talked to so many clients and inquiries where people said, oh, I have been waiting for 3 years so that I get out of these excess absences and all. But no, many times when they talk to me beforehand, it would have been sorted. Thank you very much. Do subscribe to our channel and like this video. Thank you for watching.